Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Hello, and welcome to another episode of the Wolf Theiss Soundshot. Today's podcast focuses on the relationship between competition law and sustainability, and more specifically, the question if competition law is about to become green. This episode is hosted by Wolf Theiss lawyer and member of our competition team in Vienna, Martin Gassler, who is joined by competition law experts Viktoria Robertson and Simon Holmes for this interesting discussion.
Hello everyone, we're here today to talk about sustainability and competition law. The question here is whether competition law is about to become green. This is at the moment one of the hot topics in competition law. And while we could talk about many things here, we'll focus on the horizontal competition law rules applicable for corporations, also in a sustainability context. So I'm very pleased to talk today with two very distinguished guests about this topic, Viktoria Robertson and Simon Holmes. Let me briefly introduce them to you. Viktoria Robertson is a professor at the Vienna University of Economics and Business. She's also professor of international antitrust law at the University of Graz, and she teaches competition law there and also taught competition law at the Oxford University. And she is one of the leading competition law academics in Austria, and I'm very pleased to have her here. And also Simon Holmes, he's one of the leading figures in the sustainability debate. He is visiting professor at the University of Oxford. He's also charged on the Competition Appeal Tribunal, which is the body that hears, among other things, appeals in respects to the decisions of the British Competition Authority. He has many years of practical experience in competition law. And as I said, he's one of the influential figures in the sustainability debate. And I'm very pleased to both have you here.
Hi, it's really good to be here, and I'm looking forward to talking about sustainability and competition law.
Yeah, thanks, Martin. Very pleased to be with you today.
Simon, let's start with a very basic question. So why is competition law perceived in practice as a kind of obstacle to private sustainability corporations? What is the kind of inherent friction between competition law on the one hand and sustainability on the other hand?
Well, it's no exaggeration to say that with the climate crisis, we face an existential crisis, and we need to do everything we can, use all policy tools to combat that. Of course, legislation is the most obvious tool, environmental legislation, for example, but too often it's slow, it's limited in scope, and frankly, it's not ambitious enough. We can't wait for it. Look what happened with COP26 in Glasgow. And then we come to business. Businesses can and should, where they can, compete on the sustainability of their products. But unfortunately, short term, there may be extra costs in producing more sustainable products. So they may suffer a competitive disadvantage. It's either not profitable, or if it is profitable, it's a niche product. So we need also business to cooperate, to move whole markets onto a more sustainable basis. And that's where competition law comes in. Companies have been taught, quite rightly, to be wary of talking to their competitors. If they talk to competitors, they're fearful that they're going to breach competition law. So it's that fear of competition law, that they might be accused of breaching competition law, that inhibits companies from vital sustainability initiatives together.
Thank you for that introduction. Can you give us some examples that inhibit sustainability in the competition law context?
Yeah, I'll give you a couple of examples. I did a lot of work trying to help the UK increase its recycling rate and reduce the use of plastics, requiring cooperation between suppliers and retailers. But the whole process was slowed down by constant fear of competition law. Another example would be trying to do an agreement not to source fish on an unsustainable basis. And somebody says, isn't that a collective boycott illegal? Well, no, it wasn't on a close analysis, but you can see how that held such things back. And I've been consulted on industries as wide as trying to make the fashion industry source on a more sustainable basis, initiatives to prevent the deforestation of the Amazon, or to source things like palm oil and soybeans on a sustainable basis. These all require cooperation to fight climate change and are all inhibited by fear of competition law, unjustified fear, in my view.
So these topics are not actually new, and one can ask the question, why is there a sustainability debate at the moment a hot topic, but it's currently one of the hot topics in competition law? So Vicky, can you give us some context here? Why is it one of the hot topics at the moment?
The public sentiment towards that topic of environmental sustainability has changed. There's more awareness of the importance of saving our planet, really. So climate change has become a top priority for many citizens, young and not so young. And that, of course, also needs to be reflected and is reflected in economic policy and in policy priorities. Now, against this background, the European Commission announced its Green Deal towards the end of 2019. And I think for competition law in Europe, that was a sort of triggering event to really start our conversation on sustainability and competition law. And this has, in fact, led to a number of conferences, both at the European Commission, at the OECD, where the focus really was on how can competition law support sustainability, the Green Deal. So this is definitely a topic that's now firmly on the antitrust agenda, and now we need to see what we can make of this opportunity.
So you mentioned the Green Deal by the European Commission, and the Green Deal was all about a climate-related goal. Sustainability, though, can be much broader and not just entail environmental considerations or climate-related objectives. Does the current debate in competition law only focus on kind of the climate debate and only kind of ecological, environmental factors, or is it much broader than that?
So, of course, it is true that sustainability or sustainable development is a very broad term and concept. And as we know in the United Nations Sustainable Development Goals, there's 17 of those. So only some of those sustainability goals actually touch on what we would call environmental sustainability. But in competition law, we currently do focus on environmental sustainability. It makes sense to us in Europe because you can also repeatedly find this aim in the EU treaties, but it is a question that, or a focus that could broaden in the future to take into account more diverse sustainability goals.
I agree with Vicky. We can take into account other things, but this often comes up when people say it's too difficult to incorporate environmental sustainability into competition law. Isn't it a slippery slope with other people wanting to incorporate everything under the sun, every concern that they have? My answer to that is twofold. As Vicky says, climate change is the central focus of the Green Deal at the moment, and climate change is something we must fight. If we're going to focus on any one aspect to incorporate into competition law, it has to be climate change. And all other considerations, however important they are, should stand or fall on their own merit. Things like worker conditions, but we shouldn't let any difficulties there undermine the focus on climate change.
What I'd like to add to that is that at the same time, we shouldn't forget that there is no actual consensus on what constitutes environmentally sustainable behavior. So just think of how the European Commission is currently considering to let nuclear power pass as a sustainable form of energy production. So there's an additional debate going on that has to be led on what sustainability actually means as well.
So let's then give the listeners an overview over the competition authorities in Europe and how they view that topic. Simon, let's start with the Commission. The European Commission is certainly one of the big players when it comes to competition law in Europe. It used to have the monopoly over the application of the individual exemption. That is probably the one provision that is the most relevant here in the sustainability context. Just to briefly explain that. So in Article 101, paragraph 3, there is an individual exemption from the cartel prohibition if you satisfy certain conditions. And a lot of people argue that that's the most relevant provision in the sustainability context. And it used to be that the Commission had a monopoly over that provision. And that has changed in 2004 when the whole architecture of EU competition law has changed, and also national courts and national competition authority could apply that provision. So Simon, why is that relevant here in the sustainability context?
I think I'd make 2 points. First, it reminds us that the period since about 2004, which is some 18 years, has to be looked at in the context of the fact that we've had competition law since, 1957. And we will presumably have competition law for much longer. So that is the aberration or the detour from what has been the position in the past and what can be the position in the future. It's not set in stone. And the second point is that there were a number of good cases, and what the standout case for me, which illustrates, is the CSED or washing machine case. And that was where the Commission gave an exemption between producers of washing machines to phase out the least energy efficient machines and to agree certain energy efficiency targets. And the Commission approved that, not despite the fact it would lead to price increases, because they recognized that the environmental benefits, not just to the individual people buying those washing machines, but to society more generally, outweighed those costs. That was an excellent decision, and we need more of that sort in the future.
There are a lot of cases in the past, but it's kind of funny that all the cases, at least of the Commission, that concern sustainability or kind of green cases, they all concern the period before that decentralization. And at the moment, the cases are missing. Do you think cases are important in the sustainability context?
Yes, I do. And we'd like to see more test cases coming to the Commission. It requires industry to step forward and take cases to the Commission. They say they're willing to look at these now. But of course, it's not all bad news, because of course, with self-assessment, companies can do and have been doing agreements which don't need to be notified to the Commission as they used to have to be. And the good news is the competition authorities have not been pursuing cases against sustainability initiatives. So what I'm talking about is the fear of competition law, not the actuality of competition authorities pursuing laudable cooperation agreements to fight climate change.
So Vicky, let's talk then about the current position of the Commission and how that has changed in the last years. I'm having here speeches of Commissioner Vestager in front of me and just reading these statements out, because one gets the impression that the Commission is rather reluctant or more conservative, very cautious in the sustainability debate. So one quote here from Commissioner Vestager from September 2020, where she said, "Competition law is not and cannot be in the lead when it comes to making Europe green." In February 2021, she said, "Competition policy is by no means the main tool to reach our green goals." Why is the Commission so cautious? Or can you give us some context here? What has changed in the last year on the Commission's position?
Right. So let me start by saying that the way I see it, the Commission is still carving out its response to the issue of environmental sustainability and competition law. So perhaps we shouldn't characterize it as reluctant, but rather as cautious, like you said. And the case that Simon mentioned before, the washing machine or CSED case, is actually a good illustration of what the Commission can do to accept sustainability arguments in its antitrust assessment. And perhaps this is an approach that could now be revived. We do know that the European Commission is currently revising a number of its soft law instruments, like the horizontal cooperation guidelines and also the vertical guidelines. And those are instruments where the Commission could include the topic of sustainability. We have an indication that this might actually be happening because in September last year, the European Commission published a policy brief on how competition law can help achieve the green goals. So in that policy brief, the European Commission seems to be coming around to the idea that environmental benefits could fit within its antitrust analysis, although it's not yet quite comfortable with the idea that out-of-market efficiencies can be valued in the same way as in-market efficiencies. So we'll see how that evolves. And another issue that I'd just like to draw attention to here is that it's not only environmental sustainability that the Commission is contending with, but also to actually combine the green goals with its digital goals, because the European Commission wants to have a green and digital economy for Europe. So to combine these goals is actually an additional challenge that the Commission is facing at the moment.
Yeah, that's a rather good point. And we'll come on to these two issues you mentioned, the out-of-market benefits and the type of benefits later. Simon, before that, I just want to give the listeners also an overview of other competition authorities in Europe. And one competition authority is kind of, you say they are the market leaders in the sustainability debate. They are very active and they publish a lot on that and encourage businesses to actually contact them and get in touch with them. It's the Dutch Competition Authority. Why do you think Dutch authority is kind of the market leader here?
Well, I think there's three standout points that the Dutch authorities are making in their draft guidance. One is that they have singled out what they call environmental damage agreements, which roughly corresponds to the sort of agreements that we're talking about today, those dealing with ecological sustainability, as you and Vicky have called it. Secondly, they're taking a pragmatic approach. In particular, they have recognized that it's not every agreement where you need to quantify in with formal economics that the benefits outweigh the costs. And they take a common sense view. For example, recognizing you don't need to quantify the effects of an agreement if, for example, there are limited market shares, or on a quick look, it's clear that the harm to competition is much smaller than the benefits to an agreement. And the third reason is they're saying to business, look, if you follow our guidelines in good faith, and even if we subsequently disagree with you, you won't be fined. And that gives business considerable comfort.
So you are based in the UK. What is the position so far of the British competition authorities, the Competition and Markets Authority?
Well, so far, I think they've been pretty cautious. Their focus to date has been to be sort of world leaders on the digital agenda. At the beginning of last year, they produced a very low-key document giving some very basic guidance to, particularly to smaller businesses. But I think there is potential for them to be more ambitious. They've said clearly that climate change and supporting the transition to a low-carbon economy is a strategic priority, but it remains to be seen what that means. They carried out a consultation in the autumn, and we can expect some sort of policy statement from the UK authorities in the next month or so. We don't yet know what form that will take.
Okay, so we talked about the competition authorities in Europe, the European Commission, the Dutch, the British Competition Authority. Well, there's another perspective on that topic, and that's kind of the legislator perspective. So Vicky, in Austria, the legislator actually decided to amend the national equivalent of Article 101, paragraph 3, that is the individual exemption from the capital prohibition, to essentially make it greener. That push towards a greener competition or actually came from the legislator, not from the competition authority. Can you explain the background of that provision and how it evolved, and what's the focus of that provision, of that amendment?
So this amendment took the Austrian competition community somewhat by surprise when it was announced in the spring of 2021. Back then, the Austrian competition laws had to be amended because the ECN Plus directive had to be implemented. And also it was known that the legislator wanted to address some digital issues as well. But then it included this new sustainability exemption, which, as far as I can see, is a world first. So if that's okay, I'll just quickly read that to everybody so you know what we're dealing with. So as you said, this is within the context of this individual exemption for anti-competitive agreements. And added to the 4 conditions that we already have in EU law, and the Austrian provision is an exact copy of that, Austria now has this added sentence, which is, consumers shall also be considered to be allowed a fair share of the resulting benefit if the improvement of the production or distribution of goods or the promotion of technical or economic progress substantially contributes to an ecologically sustainable or climate neutral economy. So there's 2 main aspects in that new provision. The one is that it establishes that sustainability benefits can be considered when we think about granting an individual exemption to cooperation between businesses. And it also sets up the presumption that a fair share of these benefits is then passed on to consumers, no matter whether they're actual customers of the companies that are cooperating or whether it's just society in general.
So one interesting aspect of that, it's a national provision, and certainly one has to consider kind of the relationship between that national provision and EU law. Is there potential friction here between that provision and EU law?
So the answer to that question entirely depends on how we interpret EU law. If we say that this type of exemption can also be granted under Article 101, paragraph 3 of the treaty, then there's no issue. Then the Austrian provision, the sentence, is just a clarification, really. If, however, and there are some voices in both camps, so if we say that this provision goes beyond what we find in EU law, beyond what can be justified under an individual exemption in EU law, then a conflict could arise. And the Austrian legislator was actually aware of this. So in the legislative materials, you'll find the legislator saying, this provision only applies to Austrian cases where there's no effect on trade between member states. in order to avoid a clash with EU law? That is something that we're debating at the moment.
Well, it certainly doesn't give it much relevance, does it? That requirement that there is at least potential effect on the internal market is interpreted very, very loosely. So the cases where you can only apply Austrian competition law are very few cases. So few cases actually fall under purely national competition law. So I wonder what will be the effect. So Simon, these two conditions, which Vicky mentioned, and the Austrian legislator kind of focused on these two conditions. First of all, the question, what type of benefits actually are covered by that individual exemption? And the other criterion is the question whether benefits that occur outside of the relevant market can be actually taken into account. That's often described as out-of-market benefits. And I think the debate is really focusing on the latter conditions. So whether these out-of-market benefits actually count. And they are described due to camps here. Some say it's sufficient if they have some benefits, and others argue, well, they need to be fully compensated. What's your take on that?
Well, first of all, can I say that the Commission should be congratulated for recognizing now that a wider range of sustainability benefits can be taken into account. They explicitly recognize qualitative efficiencies, cost efficiencies, and even the softer things like fair trade coffee or fair trade products are genuinely benefits to consumers. Where things, as you say, get more difficult is with the requirement that consumers must get a fair share of those benefits. So the questions are twofold. Which consumers must benefit? Is it just the consumers who bought the particular products in question, or is it consumers more widely? And the second question is, must those consumers who've bought the products be fully compensated for any increase in costs, as some parts of the Commission are suggesting, or must those consumers just get a fair share of those benefits, as indeed the treaty says? Now, why is this important? Let me give two practical examples. If there are a large number of consumers of a particular product, supposing there's an agreement between suppliers of energy to make their energy production more greener, not to use fossil fuels, a large number of consumers will be buying that product. So therefore, even if, which certainly isn't always the case, short term, there is an increase in cost, the benefits for the consumers buying that energy in terms of cleaner air, etc. and so forth will outweigh those costs. The problem comes with some of the most polluting activities. Take, for example, an agreement between airlines to stop using dirty aviation fuel and to work to have cleaner fuels for aviation. Short term, there's likely to be an increase in cost, and those costs might be passed on to, say, business class passengers crossing the Atlantic, of whom there are relatively few. So the benefits to those few customers will not outweigh the increased costs. So the Commission wouldn't allow such an agreement on current policy. But that's daft, because those are just the sort of agreements we most want to see. And it is those consumers, those flying across the Atlantic, whose demand for that product is driving the pollution in question. And I ask this question, can you imagine trying to explain to your children or your grandchildren why we prohibited an agreement to phase out dirty aviation fuel because of some technicality with some interpretation of some condition in some treaty way back in 2022?
Vicky, what's your take on that? Also in light of the Austrian exemption, do you think society as a whole is kind of reflected in that provision? So when we assess sustainability corporations, do we also need to take into account these out-of-market benefits, the society as a whole, and not just the consumers of that good on the relevant market?
So obviously, on the one hand, we have the European Commission, who is slowly adapting to that idea in its policy brief. On the other hand, of course, from the Austrian perspective, this is what we now have to do. The Austrian sustainability exemption makes it quite clear that we take sustainability benefits into account as a fair share being passed on to consumers. So there's no more question on that as long as we can apply the Austrian exemption. The focus will then be on what actually counts as a sustainability benefit, because here the wording of the provision is not clear what would count as such. And this will certainly lead to many discussions, and will also be something that the Austrian Competition Authority will closely focus on when it presents its guidelines on this new exemption provision this year.
So Simon, you touched upon the question of quantification. And I think in that context, it really relates to kind of the role of economics when assessing these sustainability agreements. Can you briefly explain how the Dutch authority, you briefly mentioned that before, dealt with that, and also explain what is a challenge for lawyers who then deal with the assessment or the quantification of sustainability benefits? And there are a whole range of other challenges there, aren't there?
I think I'd make essentially 2 points. The first point is the reason I commended the Dutch for this is that it's a reminder that we don't need to quantify everything in life which is important. And the same holds true for competition law. There is a balancing to be done, but it is often a value judgment. That was recognized by the European Commission in its own guidelines on and exemptions back in 2004, and the Dutch are just reiterating that there are many circumstances where you have to exercise judgment, and competition authorities and indeed courts like the one I sit on are well placed to make a value judgment, taking into account all the qualitative and quantitative evidence. So it's a reminder of that from the Dutch. Secondly, yes, this is not a non-economic approach. Sometimes people suggest that since we moved to a more economic approach, this is inappropriate. But I would say this in some ways is an even more economic approach, because it's calling upon competition authorities, where appropriate, to take into account the best modern techniques of environmental economics. For example, the techniques to put a value on carbon and pollution and so forth. So it's a more economic approach, not a less economic approach, where it is appropriate to quantify things.
I would just like to echo Simon here, because indeed in competition law, very often the focus is on quantifying things, because we then have this almost mathematical certainty that we're doing things right. When here, that's not so easily done in all circumstances. And in some cases, it'll just be a fact that price is not the most adequate benchmark. So we'll have to think about things in more qualitative terms.
I say this only partly in jest. There is a reason why judges are called judges, and that is because they're called upon to make judgments. You don't just plug in a bunch of numbers and press a button and get an answer. If that were the case, you wouldn't need competition authorities or judges.
So Vicky, looking in the future, what are in your view possible ways forward in the debate? At the moment, it's just a debate. A lot of papers are out, a lot of draft papers, draft guidelines, a consultation. What do you see as the most likely scenarios in the coming months, particularly this year?
So obviously I'm not a fortune teller, so I can just make an assumption based on what I see. Obviously the Austrian exemption provision has contributed a first legislative attempt at making competition law more open when it comes to taking environmental sustainability into account. I would hope that this can speed up the European debate as well, which so far has focused very much on policy and enforcement priorities. And of course, having said that, we're very much awaiting how the European Commission will address sustainability concerns as well. We shouldn't forget, however, a really important factor here, and that is the court in Luxembourg, because the way I see it, it has never fully embraced this more economics-based turn that the European Commission took in the 1990s. So it is less restricted in its analytical repertoire. And based on the case law we've seen so far, I wouldn't be surprised if the court actually included environmental sustainability as an additional factor in its competition law assessments going forward.
I agree. And the key next step is really what the European Commission does. We're expecting some draft horizontal guidelines to come out, probably in early February. And there'll be a lot of focus on what they say, how they express their views on full compensation, which we discussed a moment ago. If they say this is a legal requirement, that's clearly an obstacle. If they recognize that this is a policy statement, that's helpful. But even if it's a legal requirement, there'll still be some scope for individual competition authorities, both the European Commission and the national competition authorities, to choose the cases which they pursue. And whatever comes out as a matter of law, I don't think we're going to see cases where the competition authorities are challenging genuine efforts to fight climate change.
Thank you very much to both of you. It was a very interesting discussion. And I think that topic will kind of guide us in the future, and we see a lot of more papers, hopefully cases, more guidelines, and thank you for listening.
Thank you for having us.
Thank you.
Thank you for joining us for this episode of the Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com. You can also follow us here to receive further updates on developments in law and business from one of the leading law firms in Central, Eastern, and Southeastern Europe.